So what happens next in the case of Lucy Letby? Now we know recently that Lucy Letby's first initial bid for leave to appeal was recently denied by a single judge, but we now know that Lucy Letby will appear in front of a panel of judges where her leave to appeal application will be reconsidered. In this video I'll be taking you through what that process actually involves and what will happen if Lucy Letby fails in this appeal process. So what actually takes place at this appeal hearing? Now the following information has come from justice.org.uk where it states the following. The hearing of an appeal takes place before 3 judges sitting in the Court of Appeal Criminal Division in the Royal Courts of Justice at the Strand in London. You'll be represented at the hearing by a barrister. The prosecution will be represented by a barrister as well. The barristers each put their side of the case to the judges. Your barrister goes first, followed by the prosecution barrister. Then your barrister can reply. Sometimes the judges allow witnesses to be called if you have made an application for this. The judges then decide. Most appeals take 1 or 2 hours to hear, though unusual cases can take 1 or 2 days. Generally, the judges make their decision immediately after hearing the case, and one of them gives a judgment. They will say whether or not they allow the appeal and give reasons. Sometimes, if the case is complex, they will say they will reserve judgment, which means that they will go away to think about it and give judgment at a later date. So if Lucy Letby were to fail at this stage of her appeal process, what exactly happens next? Now it states the following here. If I've lost my appeal, what then? Your rights of appeal end, or in legal terms are exhausted, either when the full court has refused to give you leave to appeal, or when the Court of Appeal has dismissed your appeal. There are 2 further ways to reopen your conviction, but they are both extremely difficult. So in layman's terms, if she fails at this hurdle, in front of the panel of 3 judges, also known as the full court, if she fails at this stage, then really that's the end of the line, at least for the foreseeable future. Unless she appeals to the Supreme Court. Now, let's just take a look at the following here. You do not have an automatic right to appeal to the Supreme Court. Either the Court of Appeal or the Supreme Court itself can give you leave to do so. The Court of Appeal must have certified that a point of law of general public importance is involved in the decision, and it must appear to the Court of Appeal or the Supreme Court that the point is one that ought to be considered by the Supreme Court. If you think this might apply to your case, you should ask your barrister for advice. If the single judge did not give you leave to appeal, which is what the case is with Lucy Letby at this current stage, and the full court also decided against your renewed application for leave to appeal, you have no right to appeal to the Supreme Court against this decision. Now for some people they're going to say, well of course Lucy Letby is going to appeal, she's an innocent woman, of course she's going to appeal. But then on the other side of this, I mean, what are the downsides of appealing? I mean, it does state in this document, well, if you appeal and it's not granted and this can affect your sentence, how the hell could it affect Lucy Letby's sentence? She's never coming out, so she's got nothing to lose, has she? This is her only chance of ever seeing the outside world again, is by going through this appeal process. So for people to say, well, she's appealing because she's innocent, is just a complete load of rubbish. It's her only option, isn't it? She doesn't have any other options apart from this appeal process. So let's take a look at the second option. We've heard about the appeal to the Supreme Court. Now we have the application to the Criminal Cases Review Commission. The Criminal Cases Review Commission can refer a case back to the Court of Appeal even after a previous unsuccessful appeal. You must have some new argument or evidence not presented at trial or on appeal. You can find out how to apply to the Criminal Cases Review Commission on its website. Now, this is something I'm actually fairly familiar with due to another case I've looked into for many, many years. This is the case of the Essex boys. The 2 individuals who were involved in that case have always protested their innocence, and I've gone through quite a lot of documentation from the Criminal Cases Review Commission regarding their previous bids. But in that case, it's certainly a lot more circumspect than that, in my opinion, of Lucy Letby. And their appeals were thrown out time and time again. And these actually take years and years to put together. It's not going to be a case of, well, okay, if Lucy Letby fails at this bid, in the coming months, then don't worry, in the next few months she can go to the Criminal Cases Review Commission and then she'll... No, it doesn't work like that. These things take years to put together. So let's take a look at the following. This should be interesting. What grounds of appeal can I use? It is important to understand that the powers of the Court of Appeal are limited. An appeal against conviction is not another trial which looks at the evidence and decides who is telling the truth. It does not look again at the facts of the case in the way that the jury did and decide whether the person is guilty or innocent. Very interesting. It looks to see if the trial judge conducted the trial according to the rules, summed up the facts fairly, and got the law right, whether the conviction is unsafe. If there is new evidence, which was not available for the trial, the Court of Appeal will sometimes look at the new evidence and decide if it might have led the jury to reach a not guilty verdict. In the same way, an appeal against sentence is not a fresh look at what sentence you should receive. The Court of Appeal will only think about whether or not your sentence was either wrong because the judge made an error, or the sentence is manifestly excessive. This means that the sentence needs to be outside the reasonable range of sentences a judge could pass. So, in order to have a successful appeal, you have to be able to show either that the judge did not conduct the trial or pass sentence in accordance with the legal rules, that there is new evidence to show that the jury made a wrong decision, or that the sentence was outside the range the judge should have passed. It is not enough to list the things that you think went wrong with your trial. That's very interesting. You have to find things which come within the areas that we have set out above. We try below to give you some idea of what things that you can and can't put forward as grounds of appeal. Appeal against conviction, what you can't successfully put forward as grounds. I am innocent. The jury should have believed me, I was telling the truth. It's not fair, I was convicted and my co-defendant was not. So let's take a look at points you might be able to put forward. Number 1, the judge's rulings during the trial. There are the decisions that the judge made during the trial. They include decisions about whether certain evidence could be heard or whether the jury should have been told about your previous convictions. These things are difficult to argue because a trial judge has a lot of freedom about how he or she conducts the trial. Very, very interesting. So if your barrister tried to argue these things in front of the judge, the Court of Appeal will not interfere unless the trial judge acted very unreasonably. Very, very interesting. Because we know, don't we, that Lucy Letby, in terms of her defence experts, if you want to call them that, they simply relied on Mario the plumber. Mario and Luigi. We had no scientist, we had no doctor to back up any sort of version of events put forward by Lucy Letby. Absolutely nothing at all. And it's interesting, they can't just say, well, we didn't have Dr. X or Dr. B or Dr. Y. They weren't allowed to give evidence, so therefore Lucy Letby needs a retrial. They can't do that. They cannot do that. Again, these things are difficult to argue because a trial judge has a lot of freedom about how he or she conducts the trial. So if your barrister tried to argue these things in front of the judge, the Court of Appeal will not interfere unless the trial judge acted very unreasonably. Let's move on to point number 2, the judge's summing up. The trial judge has a lot of leeway in how he or she sums up the case for the jury. The judge should have explained the law in simple language. He or she does not have to give strict legal definitions. He or she should have also given an outline of the defence case, but this does not need to be in great detail. It's quite interesting. It is rare to succeed with an appeal on the grounds that the trial judge was biased against you, or did not put your case fully enough. Even if you can show that the trial judge made a mistake, you will only succeed if the mistake is likely to have led the jury to find you guilty. Let's move on to the next point, jury issues. You may want to object to a particular member or members of the jury because you know them or for some other reason you think that they decided your case unfairly. This is difficult to do after you have been convicted because objections to the members of the jury should have been made at the time of the trial. You can only raise issues about individual members of the jury if the evidence about them has been brought to your attention after conviction. Even then, it is hard to succeed if the evidence is only about one of the 12. You may think that the judge put pressure on the jury to reach a verdict. Now, this is another sticking point for many people. Oh, The jury took so long to decide this, that and the other. So let's take a look at what it says here. You may think that the judge put pressure on the jury to reach a verdict if they were not given enough time to decide. In general, the judge should try to give 2 hours to try to reach a unanimous verdict before saying that he or she will accept a majority verdict which is based on 10 people agreeing. So as I say, a lot of people have said, well, the judge put pressure on the jury, this happened, that happened, you know, they were forced into making a decision, they didn't all agree, all this sort of bloody nonsense that people come out with. But the truth of the matter is that the judge gave them 76 hours, 76 hours of deliberation before he then asked for a majority verdict. And bearing in mind, just read that again there. In general, the judge should give the jury 2 hours to try to reach a unanimous verdict before saying that he or she will accept a majority verdict which is based on 10 people agreeing. 76 hours. A lot of time, a lot of leeway, a lot of patience and consideration were given to the jury during Lucy Letby's trial. Let's move on to point number 4, disclosure issues. You may think or know that the police or prosecution did not tell your lawyers about important evidence which they had. For example, information or witnesses which would have been helpful to your case. This must be evidence that is so important that the jury would probably have found you not guilty if they had known about it. This is a complicated subject, and if you think it affects you, you should seek legal advice. Point number 5. New evidence. New, often referred to as fresh evidence, does not just mean evidence that was not called at the trial. Before you can use new evidence in an appeal, you also need to show that there was a good reason why the evidence was not called at the trial. So certainly another point relevant to this discussion is the fact that Lucy Letby's defence team can't simply go away and say, well, we had these experts, we've got this evidence that we had at trial, but we didn't feel it was relevant, and now we're bringing it forward as a means to appeal. They can't do that. They can't do that. That's not classed as new evidence. Examples of evidence which is not usually new evidence. A witness at trial who now wants to add some extra evidence. Well, they didn't have any defence experts anyway, so I guess that's out of the question. Someone that you or your lawyers knew about who was not called as a witness. Now this is very, very important. Someone you or your lawyers knew about who was not called as a witness because it was decided that he or she would not help anyway. Now, I know for a fact that Lucy Letby's defence team had a number of experts who weren't actually called to the trial itself. They had a pre-trial meeting, they had pre-trial discussions, but they weren't called as expert witnesses. So that's very, very interesting. It's not as if that they can now say, well, we had these experts and now we're bringing them forward. They've got something to say. The appeal court needs to hear this. They can't do that. Someone you or your lawyers knew about who was not called as a witness because it was decided that he or she would not help anyway. Now, we don't know why these defence experts didn't actually appear at the trial. We don't know whether they didn't want to appear, whether it was agreed that they wouldn't appear, or whether the defence team said it's best if they don't appear. We've got no idea why they didn't actually appear in the trial itself, but we do know for a fact that they were involved in these pre-trial meetings. So there was discussion with experts on behalf of the defence, but as I say, they didn't appear in the trial itself. Let's continue on with point 5 here. It may be new evidence if you can show that there is evidence which your solicitors should have obtained for the trial but did not. But it is unusual for the Court of Appeal to accept this. So if Lucy Letby's defence team say, well, we had witnesses that should have been called but they weren't, or we had evidence, scientific evidence that we knew about, but we didn't bring it to trial, I don't think that's going to go down particularly well. It may be new evidence if you can show that there is evidence which your solicitors should have obtained for the trial, but did not. But it is unusual for the Court of Appeal to accept this. Now, let's move on to some examples of new evidence that they believe is quite helpful. New scientific evidence or tests. A new witness whom no one knew about at the time of the trial who has come forward with relevant information. Now, it's important that we step back and actually remember before we get a bit too carried away with what I'm about to read to you next. because it's important to remember where Lucy Letby stands in this appeal process at this point in time. She's already been denied by a single judge. So how likely is it that this appeal process or this appeal documentation contains new scientific evidence or tests? I would say highly unlikely. Highly unlikely. Because if they had some sort of new scientific evidence or test which proved Lucy Letby's innocence, then why has that initial judge basically shut the door and said, on your bike? I mean, the way that I've read this is that the appeal that's going to go before these three judges is basically the same appeal, but it's being read by three judges instead of one. So I find it highly unlikely that this appeal actually contains new scientific evidence or tests. So let's just put that out there. Again, I could be wrong. Maybe it does, maybe it doesn't. But I find that highly unlikely, shall we say. Point number 6, lawyers' mistakes. You may feel that your conviction was because of your lawyer's mistakes, either because your solicitor did not prepare the case properly, or because your barrister did not put it over well in court. It is very difficult to use this as a ground of appeal. In order to succeed, you'll have to show both that the mistake was a very serious one, and the mistake caused your conviction. If you want to rely on this ground of appeal, you'll be asked to sign a waiver of privilege form, see page 13. So again, highly unlikely that Lucy Letby can simply turn around and say, well, my defence wasn't good enough, this happened, that happened. I know that there was one technicality in her case, and that was regard to one of the father's evidence, one of the parents, the father of one of the children in this case, and whether it was agreed evidence or not that a statement should have been read out, and then Lucy Letby said she didn't accept it, and then her defence barrister had to stand up the next day and basically say, yeah, we shouldn't have allowed that to have been read, and yeah, there's all sorts of confusion. But I don't believe it was a single point that convicted Lucy Letby. Let's just put it that way. So again, it is very difficult to use this as a ground of appeal. So to summarise this particular video, it would appear that once Lucy Letby goes before this panel of judges, if she were to then fail in her bid for freedom or her bid to appeal her conviction, then really that is going to be the end of the line, unless there is some new groundbreaking evidence which comes out after this appeal, and they can then convince the Criminal Cases Review Commission to then go forward with the appeal process. But again, let me just say to you, the Criminal Cases Review Commission, all this sort of stuff takes years to put together. This isn't just a case of, well, we've got new evidence, let's put it to the Criminal Cases Review Commission, and within a couple of weeks we're going to have a hearing and then we'll move forward from there. It doesn't work like that. These things take many, many years to come to fruition, or to come to any sort of conclusion, shall we say. Now, I don't know whether I am going to attend this hearing. I may attend this hearing in London because I am desperate to know what Lucy Letby's grounds of appeal actually are. Is it some sort of legal technicality? Is it some sort of new scientific breakthrough that shows that Lucy Letby is actually this poor, innocent individual? I don't know. I've got no idea. And I'm not actually sure whether this hearing is going to be covered by the media. So it may be that I do actually attend this hearing in person just to get the lowdown on exactly what Lucy Letby's appeal contains. Anyway, as always, if you enjoyed this video, don't forget to give it a thumbs up and subscribe down below for more content. And as always, many thanks for joining me for this one. I look forward to seeing you all again for the next one. Take care. Cheers.